Before this hearing even gets underway, pay close attention, because this case is about to take a turn that nobody in the courtroom can fully control. The defendant is facing a felony auto theft charge along with multiple domestic assault allegations, and the timeline itself raises questions. The alleged incidents happened months earlier, the case was filed later, there were missed court appearances, and now everyone has finally arrived for what should have been a crucial preliminary examination. But in criminal court, the strongest charge in the world means very little if key witnesses don't appear. Will the prosecution move forward? Will the case fall apart before testimony even begins? And what does that mean for the defendant's future? Stay with us, because the next few minutes reveal just how much a single missing witness can change the course of an entire criminal case.
This is the time that has been scheduled for some preliminary examinations this afternoon. We had one in the matter of People versus Trevor Arbogast. File number was 26260FY. Mr. George emailed the prosecutor and the court before lunch indicating Mr. Arbogast had executed a waiver. And so that matter will not be going to a preliminary examination. The other case that was scheduled for this afternoon is People versus Savan Gowan. That's file number 26335FY. That's you, sir?
Yes, sir.
You're here with your lawyer, Mr. Paul Gibson. You're charged in that case with unlawfully driving away an automobile of another, sometimes called UDAA, or auto theft. That is a felony. It's punishable by up to 5 years imprisonment and suspend your driver's license. And you have 2 counts of domestic assault alleging the assaulted Katie Ann Brandeis. This matter is kind of old. It allegedly occurred last October. It got filed in February. You got arrested in May. You missed some court dates. Got reset. You failed to appear for your pre-exam on May 26th. Then you called and they reset it. We had a pre-exam and you indicated you wished to have a preliminary examination and it was set for today. Chief Assistant Prosecuting Attorney Gary Gabriel is here on behalf of the state. Mr. Gabriel, what's the circumstance here?
Your Honor, unfortunately, we did get a phone call process through the courthouse down to us to let Ms. Gowan know that her ride fell through, not Ms. Gowan, Ms. Brandeis, that her ride fell through. We called the number that she had called from within 20 minutes and advised her that she was under subpoena, that we could certainly assist in getting her transportation to the courthouse, but please to call us back so that we can make those arrangements, and that there was always the possibility I would be requesting a bench warrant for her failure to appear since she had been properly served. Diane Wilkins not only left that message, but tracked down another phone number that we've had from Ms. Brandeis and called that number. First time she called it, it connected, but there was no voice. Second time, it said the voicemail was full. There was no answer, so we couldn't leave a message on that phone. It is now almost 1:30. Deputy Middow is present in my court, in my office. I did talk with him about whether or not we should be concerned that she was under some kind of threat or fear, and that's why she might not have been here. Every indication the officer had from the initial complaint was that was highly unlikely. There had been some indication she wasn't that interested in pursuing the assaults, but was more interested in the car. That being the case, we are unable to proceed, and I am not going to request an adjournment in light of what I understand her position to be. She can always recontact the office if she wants, and certainly would be a dismissal without prejudice, and we could reconsider our decision not to go forward at that point in time.
All right, I will allow a dismissal without prejudice. The defendant did post a bond.
Aaron, would the court want a paper formal
I would ask for one.
dismissal?
It looks like it was there's no cash in here.
This is one of those moments that reminds everyone watching how critical witness participation is in criminal proceedings. The prosecutor has just explained that the alleged victim failed to appear despite being subpoenaed, and the office even attempted to arrange transportation. When a key witness is unavailable, prosecutors must decide whether they have enough evidence to continue, or whether moving forward would be a losing battle. Notice something important here: the dismissal is being requested without prejudice. That's legal language with huge consequences. It means the case is being dismissed for now, but it is not necessarily gone forever. If the witness later cooperates or new circumstances arise, prosecutors may have the option to refile. At the same time, listen carefully to the court's discussion about the defendant's other pending legal issues. Even as one case appears to be collapsing, other criminal allegations and probation concerns remain on the table. What do you think? Is this simply a witness who no longer wants to participate, or is there more to the story than we're hearing today? Let us know what you would conclude from the facts presented so far.
Surety bond. All right, as I indicated, Mr. Gowan has other issues. He has a charge of assault and battery on somebody named Kia Krantz. That's set for a pretrial on Friday in front of Judge Patterson. You're aware of that?
Yes.
That's 8:30. Apparently, that person alleges that you beat him up for reasons unknown. You also have a probation violation arraignment set for July 6th. And there's no need to wait for July 6th to do the probation violation arraignment. You're here. So I'm gonna do that right now. In file number 251958, you're placed on probation for malicious destruction of property, which I believe was Katie Brandy's property. Your probation agent, Priscilla Walton, filed a probation violation petition June 15th, alleging that you got charged with some new criminal matters and you failed to report to the probation department on a monthly basis. That case was before Judge Patterson. But as indicated, there's no need to wait to do the arraignment. Mr. Gibson is here and he can stand in as advisory counsel. In that case, it's alleged malicious destroyer your vehicle tires relationship with. Based on probation, the probation agent still says, Mr. Brown placed on 24-month probation on the same trial for malicious destruction of property. Mr. Brown has in violation of condition 1, picked up new charges while it's not condition 265 and 260. It's also in violation of Mr. Brown completed his intake as a conditional probation conditions. He was released from jail on 2/14 and was failed to report to the probation department since he was released from jail. So I was going to have a successful. He's been unsuccessful in staying in contact with the department. He's picked up new charges as well. is not showing the cares or has any interest in successful probation. Further explanation. So in light of that, this part of the jail, she found, I would recommend you to my name set up the
Does it say the date he was placed on probation?
yes.
If I'm not mistaken, the charge is being made to caught old charges of reason.
Well, this crime, we placed on probation on December 12th.
Well, it looks like the one that's set for Friday, the alleged offense date's January 10th. So it does look like
Yes.
have one,
So,
but the felony case was from October of 25.
that's true. So 26335 conduct received the probation, but the assault conduct was not done because you never even showed up. So she's right. Mr. Gallon is not showing the cares or having an interest in successfully completing this probation. So your lawyer in the original case was traumatized. So my attorney one problem with getting a new charge is you haven't had to convict it yet. It presumes to be not guilty. However, it ain't gonna be very hard to prove you never showed up for 1 second of probation supervision. So I suspect it hasn't been very happy about this. Anyway, you still need to be here Friday on the other case. And, well, you be able to accomplish the assault dismissed. Without her, so you couldn't redraw last year. It's a change of circumstance.
And just for clarification, did you say that you appointed Rhonda Ives to the probation violation?
Yeah.
Okay, I'll let her know.
Right on the court dates.
Yeah,
On Friday, 8:30.
I don't know, that might be the only one that's right now.
He's sitting here right now for the PV.
Oh, okay.
Clerk told me you did make a payment. Some of them, there's a little bunch of money, I know some different cases, but you stopped and paid.
Yeah, I set a payment plan so I can start making payments. And this last week with all this storm damage cleanup, I've been missing out money,
Because of.
helping clean up around town.
So did you make a payment today?
Yes, I did make a payment today.
That's what I thought. All right, like I said, just pass the primary happy about this bad location. That's his, his discretion. So, I should go out to the counter. And, first will give you a notice for a hearing.
Okay, I got stuff to do that.
There are my recommendations to vote for and oppose it. And felony charges dismissed without.
Thank you.
Probably try to contact your probation agent just to see if, you can start from there. She would like to report, and then maybe you can kind of get back on track. All right.
So Diana called that number. Left a detailed message. I just wanted to know.
Is Miss Paulina?
Nothing. And she never answered the other phone. So I'm surprised it looks so.
She's gonna be a lunch one, or is this Suzanne?
She said she can't, use anyway, she just wants some money for her car.
This is an unscheduled matter. Unscheduled matter. Well, the matter, everything happens, problem number is 261042. So you want to start with possession of that. She was set for a conference. February 9th. And the freeway for today, June 16th. The defendant failed to appear for the pre-hearing conference, and the bench conference was recommended. And for the time, 40 anyway, Mr. Was here, Mr. Gilbert, Mr. Tim George, who went above and beyond to get the this time. This is the member accused of being an express. All right, Mr. George, what's your client's preference here today?
Your Honor, I've had the opportunity to speak with my client about the conversation I had with the prosecutor. I believe it was last week at this point. At this point, we've executed a waiver, Your Honor, that's been signed by Mr. Gabriel. And we can either give that to the court or the prosecutor's office, whichever is easier for processing.
We call bench warrant. sweat case. Sometimes that. So you got 2 dates to appear. You got last Tuesday morning and today at once. We actually showed up the second after 2 days. You had to write down a preliminary examination, or it must be established that this probable cause of recent crimes committed cause the kid. And you waive that and have the matter gone over to circuit court for further proceedings, is that correct?
Yes.
Do you still live on Orange Street?
No.
Don't tell me the street address, where you live right now.
I'm here and there.
Well, we need to get some sort of contact address. I was looking to see whether they had pretrial services. Can't tell who are this. There's a 3-letter, 3-sentence scratched out bond information from SWAT. Should have a bunch of criminal history that I saw. Mr. Fagino is an old 3-year-old's name. Which branch of the Faginos are you from? Who's your parents?
Kimberly Fagino, which is Avery now, and James Anthony.
Okay. Do you have any contact with your parents?
Not recently, no.
139 Portage Avenue is a Richmond address. The Richmond zone, I think a bunch of people were squatting there. So I don't think that was even really real address. Where do you mostly spend your time?
I'm just out here and there. I don't really have no, I just bounce around from couch to couch, really.
All right, we're gonna need some sort of address.
And Your Honor, she does have someone with her today. I think she was going to give me that address that I could use for mailing. Is that correct?
If she's okay with it.
Can she use your address or else? They do. It says they don't have much criminal history. This is a meth case of some import in the Southwestern Forces. They tend to focus on large cases. Most of them who didn't show up when they're supposed to be here today. Do you have a telephone number?
Yes.
Assuming you're not employed. Are you employed?
Not yet.
What kind of work have you done?
Mostly kitchen work.
Restaurant kind of stuff?
Yes.
Where did you last work?
I worked at the dairy bar a couple of years ago.
In the kitchen?
Yeah, I was a dishwasher.
I think I've seen you in there. I used to go in there quite a bit. Something else. What other kind have you done?
I used to work at Steak and Shake and Cracker Barrel.
All right, well, you are sparrow on hurricane. I'm gonna order for child services, so she's at least checking in with something. I'm assuming if I gave it a drug test, then it probably would be very drugs. Bond conditions. Personally appears or any hearing required by the judge and do not need to state the issue, do not commit crime by email, telephone number, use alcohol or controlled substances. Thus prescribed by assault, harass. And I'm gonna add condition U. Corrections. All right, I'll accept your waiver. I have jurisdiction on the top sign the waiver, so therefore we can in the spot. The waivers in the works. It's got to be some weeks or months before your case is scheduled for as conferences. Can't leave the state of Michigan without permission of the court, which is a little bit short. You can go to Hope, you can't go to High. So you go anywhere in the state of Michigan, you can't leave Michigan without permission of the court. Not using drugs or alcohol. I suspect that they were tested as probably positive. And they ask you to take a test at some future date. But I'll leave it at that. I'm gonna have the court also take out the time.
Your Honor, for that initial conversation with community corrections, does she need to go out to the training center or is it a phone call?
There's a phone number.
Okay. Thank you, Your Honor.
It's in the conditions. You contact the corrections by telephone the very next business day after release from jail. Supervision and one eligibility when you do that's not. I don't think it's a lot. It's very much all right, thank you.
Thank you, Your Honor.
Any questions?
This is one of those moments that reminds everyone watching how critical witness participation is in criminal proceedings. The prosecutor has just explained that the alleged victim failed to appear despite being subpoenaed, and the office even attempted to arrange transportation. When a key witness is unavailable, prosecutors must decide whether they have enough evidence to continue, or whether moving forward would be a losing battle. Notice something important here. The dismissal is being requested without prejudice. That's legal language with huge consequences. It means the case is being dismissed for now, but it is not necessarily gone forever. If the witness later cooperates or new circumstances arise, prosecutors may have the option to refile. At the same time, listen carefully to the court's discussion about the defendant's other pending legal issues. Even as one case appears to be collapsing, other criminal allegations and probation concerns remain on the table. What do you think? Is this simply a witness who no longer wants to participate, or is there more to the story than we're hearing today? Let us know what you would conclude from the facts presented so far.